of accused number 3, and we are on page 2, and 16 additional photos of accused number 2, which were found on the SD card or the memory card on his cell phone. And these photos also include 2 photos of accused number 1. We mentioned that these additional photos do not form part of any of the exhibits that are before court, but are contained in the totality of the photos that were downloaded on these gadgets mentioned above by the downloaders, namely Sergeant M. Mabasa and Warrant Officer L.T. Ndlovu, respectively. Paragraph 1.2. The state is therefore bringing an application for the recalling of Sergeant Mabasa, the downloader of the cell phone of accused number 3, as per Exhibit S. The court will recall that the evidence that the investigating officer requested at the time that only certain photos found on the downloads of accused number 3 should be included in Exhibit S, being the affidavit of Sergeant Mabasa. Those photos are also included in the affidavit of Lieutenant Colonel Stein, and he has also testified thereon, and they were included in the affidavit of Lieutenant Colonel Stein at the request of the investigating officer, Brigadier Gininda, in order to identify the clothing and the dreadlocks of accused number 3. And this, my lord, we see on the record of the proceedings of the 1st of August 2023, page 8, lines 10 to 11. We mentioned, my lord, that the total number of photos downloaded on the phone of accused number 3 is quite substantial. If my memory serves me well, I think they're in excess of 700 photos. The evidence in chief and cross-examination of Sergeant Mabasa have already been concluded on 1 August 2023. He was subsequently recalled on 24 May 2024. But his evidence has already been dealt with. The CD containing all the photos that were found on the download of accused number 3, and not only those contained in Exhibit S, the affidavit of Sergeant Mabasa, and Exhibit O, that's the affidavit of Lieutenant Colonel Stein, were handed to the defense some time ago. We don't want to commit to a specific year, but it's quite some time ago, my lord. The state seeks to hand in a photo of accused number 3 in the context of 3 versions of the same photo emanating from the extra photos contained in the download, which do not form part of either Exhibit S or currently. Paragraph 1.3. The state also seeks to recall Warrant Officer L.T. Ndlovu, the downloader of the SD or the memory card found in the cell phone of accused number 2, which was a gold Samsung cell phone. Now, according to his evidence, there's now the evidence of Warrant Officer Ndlovu. The cell phone had 2 SIM cards, which, along with the SD card, were successfully extracted using the XRY technique, but the cell phone itself could not be successfully extracted as it had a pattern as it was mentioned on Friday. And this we see on the record on the 16th of April 2024, page 18, line 7 and further. He testified that the results were burned on the CD and sealed in a forensic bag. And we mentioned that Warrant Officer Elton Ndlovu has already testified and has been cross-examined. If I can then ask the court to turn over the page to page 3, paragraph 1.8. We deal with the law as far as the recalling of a witness is concerned. And we mentioned, my lord, that this application is based on the rule of practice that dictates that in an adversary system such as ours, that there is a search for the truth in order to ensure that justice is done. In other words, there's a need to put a full and fair picture before the court. And our application is also partly based on the principles that were enunciated in R versus Hepworth. We've given this citation on Friday, 1928, AD 265 at 277, wherein the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other, and that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. In paragraph 1.9, we submit in the alternative, my lord, that section 167 of the Criminal Procedure Act 51 of 1977 also deals with the current application that the state is bringing, and it says that the court may at any stage of the criminal proceedings examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and the next portion we bold, my lord, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. We also refer to section 186, actually, my lord, not 86, section 186 of the Criminal Procedure Act, which provided the court may subpoena a witness if the evidence of such witness appears to be essential for the just decision of the case. And should we not be successful on the general principles, my lord, we request that the court should exercise the powers conferred on it in terms of section 167, as we have alluded to. Now, in paragraph 1.11, my lord, we set out the reasons as to why it is essential to re-examine Brigadier Gininda on these photos. We've already dealt with paragraph 1.11 on Friday, my lord, up to page 6, my lord. We quoted the contents of these pages verbatim on Friday. We are not going to rehash that. we are going to deal with the reasons why evidence was not led in examination in chief of these witnesses. This is on page 6, paragraph 2.1. As we alluded to earlier on, the investigating officer requested at the time that only certain photos found on the downloads of accused number 3 should be included in Exhibit S, the affidavit of Sergeant Mabasa. And as we've already intimated, these photos are also included in the affidavit of Lieutenant Colonel Stein at the request of the investigating officer, Brigadier Gininda. And the purpose at the time was to identify the clothing and the dreadlocks of accused number 3. So the focus, my lord, was mainly on the clothing and the dreadlocks. Now, evidence has now been presented before the court, and there's been cross-examination. The state intends to present the additional photo of accused number 3 in its 3 forms to show other features of accused number 3 that were canvassed during cross-examination by Advocate Nisi, such as the gold tooth. Paragraph 2.2. Insofar as accused number 2 is concerned, the state seeks to show more photos as further appearance of accused number 2 as came up in the cross-examination of Brigadier Gininda, as an issue was joined with him regarding the identification of accused number 2 by the witnesses. And the same argument obtains for number 1, my lord, that the state wants to show his general appearance as testified to by the witnesses, and in particular Brigadier Gininda. Paragraph 2.3, we deal with the reason why the evidence was not presented during evidence in chief. We mentioned, my lord, that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination, that the state was able to go through the over 5,467 photos of the downloads of accused number 2. And we make the point, my lord, that these downloads were given to the defense a while ago already, and that the state has extracted a photo from the cell phone downloads of accused number 3, which, if the application is successful, will be presented in 3 different forms. And 16 additional photos were also extracted from accused number 2's downloads, including actually 2 photos of accused number 1 that we want to show to the court. We mentioned, my lord, that accused number 2 and 3 do not dispute the cell phone or stroke SD card from which the downloads were made belong to them. We mentioned that in light of the fact that the photos belong to them, including the 2 photos of accused number 2, that they therefore fall within their personal knowledge. We therefore, my lord, submit that there will be no prejudice to them. In paragraph 2.4, we mentioned that the evidence will be of short duration, as the downloaders are simply going to confirm that the downloads were burnt on the CD and authenticate, and they will just authenticate those photos. And on page 7, my lord, we deal with the interests of justice. We have already placed our argument on this point on Friday, my lord. We're not going to repeat that. Safe to mention that in paragraph 3.1 that it is respectfully submitted that it is in the interest of justice to allow this evidence, as it will assist the court to adjudicate on the issues that are in dispute, and that the evidence is therefore relevant. We again quote the case of R versus Hepworth, the case of State versus Sheikh and others. Paragraph 3.4, the multi-choice limited and others versus the National Prosecuting Authority and another. And on page 8, paragraph 3.5, we also repeat the authority that we quoted on Friday. And in conclusion, my lord, and I see there's a typing error there. We respectfully submit that the state be allowed to recall these two witnesses. I'll try to establish the attitude of my colleagues to this application this morning, but they were still going to have a discussion. I'm here to be apprised of what standpoint they will adopt regarding the application. As the court, please.
You want me to adjourn?
As the court pleases, my lord, that was going to be my suggestion, in the light that I also stand in for Mr. Mngube and Mr. Sibia, so that I can take proper instructions, my lord. As the court pleases.
When should I come back?
I'd suggest, my colleagues, sorry.
It's 4 minutes to 11. Maybe we can take the short adjournment and come back at 11:30 if it's fine.
That will be suitable, my lord. As the court pleases.
Is that okay? 11:30.
As the court pleases, my lord.
Interpret for them first.
khona ke udaba ke bafowethu la kade silidikida ke esontweni elidlule ke malana phecelezi nezithombe lezi ade befisa ukuthi bezijobeleleke kufakaza obukhona ke beyithombe bohambisana nemibukiso ka exhibit S ke lapho ke phecelezi izithombe lezi ziquka khona ke umnumzana uSibiya ke uqala ke futhi umnumzana uNtanzi futhi nomnumzana wesithathu ke lapho ke laba khona khona ke ngezithombe bangathanda ukuthi babize futhi abofakazi ababili ke lapho ke warrant officer Mabasa futhi no Sergeant Mabena warrant officer Ndlovu futhi no Sergeant Mabena kuthizini baze futhi kwinkosi enkantolo ke bethi ufakazi babo malana nezithombe lezi phecelezi la khona ke khulunywa ngezithombe ezimbili ke zakamsola oqala ke futhi lapho ke futhi nezithombe ezintathu futhi nezithombe ke lapho ezishumi enesithupha ke zakamsola wesithathu ke lapho ke futhi nezithombe ezinye ezikhona ke lapho ke zakamsola wesibili la bangathanda ukuthi bakhulume phecelezi ngazo ke la bazabakhuluma khona ke ngezithombe zakamsola wesithathu ukuthi khona la bangathanda ukuthi bakhulume ngazo ke kepha ke izithombe lezi eziqhamuke ngendlela ezintathu ezahlukile ke lapho ke la sitshengisa yena khona ke anama threads la ke ke ekhanda futhi wathi ithombe lezi bathubula ngaphakathi ocingweni lwenu ke banumzana futhi ezinye izithombe lezi bathubula ngaphakathi kwe SD card shothi memory card ke lapho ke manje bathi bakhulumile ngazo mayelana nodaba lolu le XRY system lapho kade be download khona ke warrant officer Mabasa futhi bakhuluma ngazo ke futhi bese wasifaka ngaphakathi kwe CD noma idisk ke lapho ke ngemuva kwalokho ke bisofaka ngaphakathi kwesikhwama lesi isikhwama sivalekile bathi exhibit back ke lapho ke lezi bangathana ukuthi bakhulume ngazo manje ithimba labameli benu ke lapho ke liyacela ukuthi inkosi enkantolo ithi ukuhamba kancane ithathe ithole isikhashana esincane ke la bazokhonti bakhulumisana ngezithombe lezi ke bese bakhulumisana nani ke lapho ke futhi washo khona njalo ukuthi umnumzana uRamusipile naye ke futhi lapho ke uyena ke ongene icathuleni zaka baba umnisi ke ngoba yena ngekho laphambi kuke senkantolo futhi angathana ukuthi ke akhulumisane nabanumzana laba abamele ubaba umnisi phecelezi ngodaba lwezi lolu lweyithombe ke.
Okay, thanks. 11 then.